fate of George Zimmerman is now in the hands of the jury. Deliberations in his second-degree murder trial began a few hours ago after the defense, the prosecution, and the judge got in their final words. About 90 minutes ago, the jury asked a question about seeing a list of the evidence, fairly common according to our senior legal analyst, Jeffrey Toobin. Earlier, the defense attorney, Mark O'Mara, made the closing argument to acquit Zimmerman.
You look at these facts, you look at all this evidence, and you have to say, I have a reasonable doubt as to whether or not the state convinced me he didn't act in self-defense. That's all you have to do. You don't have to write innocent on the bottom of the verdict form.
The judge is now coming back into the courtroom. Let's listen in.
The jury would like to adjourn tonight, 5:50 at 6 p.m. Or the notes at 5:50. Let me reread it. The jury would like to adjourn tonight at 6 p.m. The jury would like to begin tomorrow at 9 a.m. if possible. Anybody have any objections?
No, Your Honor.
No, thank you, Your Honor.
Okay, what I'm going to do is bring them in here and give them their admonishment and release them until 9 a.m. Okay? Okay, let's go ahead and bring them in.
They've ended their work for the day. So there you have it. You just heard the judge say the jury is ending its deliberations for the day. They will resume 9 a.m. Eastern tomorrow morning. The attorneys for both sides had no problem with that. She's bringing the six ladies, the six members of the jury back in. She will admonish them as she does every day. We'll listen to that admonishment. We've got our legal experts who are standing by.
In the morning as well, because
Sunny
I want to make
Hostin,
sure
Paige
that they hadn't had
and Jeffrey Toobin. Let's hear what she's saying right now. She's still waiting. She's still waiting for the jury to come in. Quickly, Jeffrey, are you surprised that they've wrapped it up for the day?
Not at all. If they were asking for a list of the exhibits, that means they're just getting started. So it was quite clear they were not going to wrap things up today. 6 p.m. is a reasonable time to start. 9 a.m. is a reasonable time to start tomorrow. They're doing their work.
Yep, they certainly are. I always like listening to the judge.
Good afternoon, ladies and gentlemen. We're going to go ahead and adjourn for the day, so you will be going into recess overnight. I just want to give you my admonitions before you recess for the evening. During the overnight recess, you're not to talk about the case amongst yourselves or with anybody else. Although you are in the deliberation stage, your deliberations are only going to occur while you're here in court in the jury room. So do not discuss the case amongst yourselves or with anybody else overnight. Do not read or listen to any radio, television, or newspaper reports about the case. Do not use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology. And do not read or create any emails, text messages, tweets, blogs, social networking pages about the case. Your notes will be locked up in the jury room. You will not be allowed to take them back with you. They will be there available for you in the morning. We will recess until 9 a.m. At that time, I will bring you back into the courtroom so we can begin court and then have you go back and recess. Will all of you abide by the instructions that I have given you? Okay, with that, please follow Deputy Jarvis. Okay, is there anything, please be seated. Is there anything else that we need to take care of before we recess for the evening?
No, thank you.
Okay, thank you very much. We'll see you at 9 a.m.
No nonsense, Judge. Deborah Nelson, they've recessed for the day, the jury and the courtroom. They deliberated, by the way, if you're interested in this, and you should be if you're interested in this case, they deliberated for 3 hours and 33 minutes today. They will resume their discussions tomorrow morning, 9 a.m. Eastern, but they're done for the day. Earlier this hour, we heard Mark O'Mara deliver a little bit of his closing argument. He's the defense attorney for George Zimmerman. The assistant state's attorney, John Guy, he had the last word. He rebutted, and he spoke about Trayvon Martin's, spoke involving Trayvon Martin's name for a final time.
To the living, we owe respect. But to the dead, we owe the truth. What do we owe Trayvon Martin? 16 years and 21 days. Forever. He was a son. He was a brother. He was a friend. And the last thing he did on this earth was try to get home. This is the dead. The self-serving statements, the lies from his own mouth, and the hate in his heart. Words that they can't now take back. The physical evidence which refutes his lies. And the law that Her Honor is about to read to you, the law that applies to all of us, and the law that applies to each of us. This is the truth.
Judge Nelson had the final words as she instructed the 6 women on the jury.
Your verdict finding George Zimmerman either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole.
That's a strong admonition. All right, let's go to Sanford, Florida. CNN's Martin Savage has been watching this from the very beginning. It's got to be 6-0. Can't be 3-3, 5-1, 6-0, either guilty or not guilty. That's the charge that this jury has. And there are 6 members of the jury. They're deliberating. They'll resume tomorrow.
Right, and there's 2 considerations they have, which is, of course, second-degree murder or manslaughter. And I think it has been the concern for the defense that the manslaughter charge could possibly be considered as a compromise charge. At least, again, in the minds of the defense, they worry that the jury could perhaps say, well, okay, it's not going to be murder, but we have a young person who is dead, and thereby manslaughter seems like a way to sort of compromise. And, of course, what Mark O'Mara said in his summation, self-defense works for everything. Self-defense is what they say. Self-defense would apply whether it is murder or whether it is manslaughter, and that is what he has argued so strongly. But, you know, it's interesting. We've now, as Jeffrey pointed out, gone into deliberations, and it appears that this jury is now looking at maybe the long haul. Maybe it's tomorrow, maybe not, but they certainly are asking now for a list of the evidence. They want a description of all the evidence. I would have thought by now they probably had polled amongst themselves, and maybe there is some division, so they realize they've got a long haul and they should get some rest. Pick it up at 9 o'clock tomorrow morning. Yeah, they've been doing it for a while. They want to do it right, so they don't want to take any chances at all. Martin, don't go too far away. Let's assess what's going on with CNN legal analyst Sunny Hostin, CNN senior legal analyst Jeffrey Toobin, and the criminal defense attorney Paige Pate. Let me bring you into this conversation. Paige, first of all, what was your bottom line assessment on this, the final day of arguments?
Well, it was a long day for the jury, and I'm not at all surprised they were ready to go home at 6 o'clock. I think the lawyers did a great job. I think the state, the prosecution, had to try to bring emotion back into this case. They certainly tried to do that. Mr. Guy's rebuttal closing argument was fantastic. For the first time in a long time, the jury was asked to step into the shoes of Trayvon Martin. You know, up to this point in the trial, everybody's been focused on what was George Zimmerman thinking, where was he, what was he doing. I think it was important for the state to remind the jury that we're here because Trayvon Martin is dead. I think that was very effective.
And listen, Sonny, to Mark O'Mara, because he also had this message to the women of the jury. Listen to this.
A dead person on a slab has an impact on you. I would say that maybe one of you, maybe, have looked at a picture like that before this trial. Maybe one. It has an impact. The other thing about autopsy photographs is that there's no muscle tone. because there's no nerves, there's no movement. He lost half his blood. We know that. So on that picture that we have of him on the medical examiner's table, yeah, he does look emaciated. But here's him 3 months before that night. So it's in evidence. Take a look at it. Because this is the person, and this is the person who George Zimmerman encountered that night. This is the person who, all of the evidence, was attacked, or attacked George Zimmerman, broke his nose or something close to it, and battered him on something. And the state now may say, oh, maybe it was just a drain box and it was no intent to hurt there by Trayvon Martin because it was just coincidence that he was bashing his head on something hard and it was a drain box. Really? Come on. Really?
What did you think of that argument, Sonny?
Well, you know, I think Mark O'Mara is a fine lawyer. I didn't see a lot of reaction from the jury. You did see Sabrina Fulton walk out in the middle of it. She seemed very upset. She seemed offended. I'm not so sure that it resonated that much, but it was an appropriate argument to make. I don't think it was inappropriate to say, you know, this is what he looked like not being on a slab. But again, you know, he was killed by George Zimmerman. Whether or not it was murder or justifiable homicide is the question. So I think to call attention to the fact that Trayvon Martin was, you know, on a autopsy slab, I don't know that it was that effective.
Jeffrey, listen to this. This is John Guy, one of the prosecutors, making an important point before the jury. Let me play the clip.
And if there was ever any doubt about what happened, really happened, was it not completely removed by what the defendant said afterwards? All of the lies he told, all of them. What does that tell you? There's only two people on this earth who know what really happened, and one of them can't testify, and the other one lied. Not about little things like his age or whether or not he went to the hospital, but about the things that really, truly matter.
Jeffrey, how effective was that?
Well, this was the biggest contrast between the prosecution and the defense. Both yesterday and today, the prosecution spent an enormous amount of time on the statements of George Zimmerman and saying his lies proved that he knew he was guilty. Today, Mark O'Mara sort of blew the issue off. He said, look, you know, these aren't significant lies. They are somewhat different tellings, and as you heard from witnesses, people always tell things slightly differently each time. You know, I did not think these lies were so dramatic that they proved George Zimmerman was guilty, but the prosecution put a lot of stock in it, and the jury certainly will remember that the prosecution claims the lies prove that he knew he had a guilty conscience.
Paige, were the lies significant?
Not necessarily, but many times a jury will look at a potential witness, a defendant, and believe that if they lied about little things, they're minor inconsistencies, then maybe they're lying about the big stuff too. And I think the state had to do this. I mean, this is the whole reason they put Mr. Zimmerman's prior statements into evidence. And that was, I think, a mistake, because then the defense did not have to call him. I think if you're attacking Zimmerman's credibility, it would have been much more effective if you were cross-examining him at trial. But at this point, all they can do is reference those statements and try to get the jury, look, he's inconsistent about some minor, then you can't of his story, and that's not the way it went down.
I'm going to have our legal analysts all stand by. We have much more to assess in this Zimmerman trial. It wrapped up today. The jury